Thank you, Stuart. A warm welcome to you all. The last thing that an employer wants is to spend many months preparing for an employment tribunal hearing, at the same time receiving positive feedback in terms of prospects of success of the case. As the hearing approaches, there are occasions when there is a nudge or a push to settle that case, if not shortly before the hearing, but on the morning of the hearing. Even worse, you could spend those months preparing a case with the end result of a full hearing, which is costly and time consuming for yourselves and the witnesses that you call, and then be unsuccessful. My name is Peter Maratos. I have 17 years' experience attending and representing companies at employment tribunal hearings from Truro up to Aberdeen and most hearing centres in between. Point one, read the room. Be aware of how your company functions at present. Is it a company that is built wholly on trust with little written documentation? Verbal warnings generally being sufficient because of that relationship between yourselves and the employees. On the other hand, do you take a more formal approach to all matters from the outset, employment contracts through to disciplinary and grievance procedures? It may be necessary at some stage to move from an informal to a more formal footing in terms of employment relations. That has to be done with care because there is a risk if that transition is mishandled that there can be a feeling or perception from the employees that they are no longer trusted. Point two, references prior to the commencement of employment. It is easy to accept a reference that is headed up to whom it may concern, and that reference generally contains relatively limited information. Those references, more often than not, have come from a prior employment tribunal because when an employment tribunal settles, it will include a sum of money, more often than not a confidentiality clause, and quite often there will be a request that within that agreement the employer provides a to whom it may concern reference for use at future employment. The employer is covered because it's factual and is neither positive or negative. It simply states the start and finish dates and the title generally, little more information, unless that can be brokered as part of the negotiation settlement. However, you do need to go behind that, look further into a to whom it may concern reference, whichever way you can do that. And one way of a simple check may not be the end check, but one way of a simple check is to Google employment tribunal decisions. They're all published, and you can put a name or a name of a company or other matters in the search terms, and all the cases will come up that are relevant to your search. Point three, always provide a written contract of employment, no matter what size your company or organisation. If there is no contract of employment and the matter ends up in an employment tribunal, there is a very high risk that there will be an automatic award of either 2 or 4 weeks' pay simply because of the absence of a written contract of employment. In addition to the main statement of terms, which needs a signature from both sides, do have a separate page that lists the rules in respect of deductions from wages, the circumstances and the amounts that may be deducted, for example, for training or for damage to company equipment. It's very important that it's a separate page that is signed rather than those terms being incorporated into the main agreement, because if they are incorporated into the main agreement, they may not stand up later at an employment tribunal. You do need separation so the employer has complete understanding. If there's no separation, you may have difficulties later down the line. And the third document that does need a signature, either at the outset or after induction training, is one that confirms the employee has an awareness of the Equality Act and the responsibilities and diversity, etc. That document may, in the future, assist you to avoid employment tribunals, but it is important that training takes. Point 4, respect maternity. Anything short of celebrating maternity can result in an employment tribunal claim that is difficult to defend and has a high value. Remember that point. It is important when the situation arises, respect maternity. Point 5, employing family and friends. It can work, it can be hugely beneficial to your organisation or company. However, there is an increased risk of matters concluding in the employment tribunal, because if the personal relationship breaks down, then that has a detrimental effect on the business relationship, and vice versa. If the business relationship goes, then not only have you got an employment tribunal, but also that risk or likelihood of the personal relationship suffering damage or becoming irreparable. If you do, however, believe that the benefit in employing friends and relations outweighs the risk, then it's very important to make sure that your documentation leaves no room for misunderstanding. Self-employed personnel. However, should the working relationship deteriorate and should the matter conclude in an employment tribunal, then there is a risk that the employment tribunal may make a finding that the real relationship was one of employee and employer, and they can overwrite the agreement that you believed was in place, even if that was a written agreement. And by overwriting and making that finding, you could be liable for PAYE backdated, for holiday pay backdated, and a finding of unfair dismissal because you believe that you were able to dismiss, for example, without procedure because in your mind it was a self-employed relationship. So avoiding tribunals is at the outset. If it's beneficial to have a self-employed relationship, make sure that everything is in place to avoid future difficulties, and have a word with accountant experts in respect of IR 35. And finally, point 7, do not be overconfident, especially where there is a claim for breach of the Equality Act, because those claims can be difficult to defend and can result in a high award. You may be overconfident where there is a denial, for example, that words were ever spoken. The position from the other side is that the words were not only spoken, but they caused offence or exceptional offence. Moving forward, you may say that we'll go to the hearing, we'll have witnesses, and we have a reasonable prospect of success. We're here to avoid employment tribunals, and what you must remember, an employment tribunal works differently to another court. An employment tribunal, yes, you will give sworn witness evidence, you will face cross-examination, there will be closing submissions. There's no difference there. However, if you're overconfident, you may believe that the defence of the words were never spoken will carry, and they may carry in another court where the test is, do we believe beyond a reasonable doubt that those words were spoken? However, that's not the test at the employment tribunal. The employment tribunal sits with an employment judge and 2 lay members, so the 3 must decide by majority or unanimous decision, 2 out of 3 or 3 out of 3. And the decision that they have to make is different to the decision that a jury has to make. The decision that the panel have to make is, do they believe on a 50-50 on balance? Do they believe on the balance of probabilities that those words were said? Therefore, at the employment tribunal, you can be overconfident. You can spend a long time preparing the hearing. You can go to the hearing, and there is a finding that, on balance, for whatever reason, after all the evidence has been heard, there is a belief, on balance from the tribunal, that those words were spoken. So it's accepting the difference between an employment tribunal and other courts. Have that awareness. Do not be overconfident. Make sure that all the equality training is in place. Not only is that prudent to avoid tribunals, but it has also become an employment law requirement. Thank you very much, Stuart, for the opportunity to give this talk. If there are any questions, I will be happy to answer them in subsequent discussions. But in the meantime, thank you very much for listening. Goodbye.